support for this amendment has been influenced by the findings of our disability harassment inquiry. The inquiry looked at disability-related harassment in both private and public spaces, carried out by individuals or groups of people, including strangers, neighbours, acquaintances, friends, families, relatives and partners, and the public authorities' responses to disability-related harassment. One of the principal findings of the inquiry was that there is systemic failure by public authorities to recognise the extent and impact of harassment and abuse of disabled people, to take action to prevent it happening in the first place, and intervene effectively when it does. As part of our inquiry, we examined 10 very serious cases in which disabled people have died or been seriously injured. A power to access was not considered by our inquiry, but a power to access is relevant to several of the 10 serious cases we examined. For example, the case of Stephen Hoskin. Stephen was a 38-year-old man with learning disabilities. His murder was the culmination of ongoing abuse in his own home over a period of time. He had been tortured for hours before his death, suffered various injuries inflicted upon him by a number of perpetrators. He had been forced to make a false confession that he was a paedophile and coerced into taking a lethal dose of paracetamol tablets. Finally, he was taken to a viaduct and forced over the railings before one of the perpetrators stamped on his fingers until he let go. Stephen's death followed a series of abusive incidents occurring over a period of months by a number of agencies, including police, health services, housing and social services, had been alerted to at some stage. Opportunities to intervene to halt the abuse were missed. Another case examined by the inquiry was that of Michael Gilbert. On the 10th of May 2009, Michael Gilbert's body was found in the Blue Lagoon at Arsley near Luton. He was 26 year old, and there is evidence that he had an undiagnosed mental health issue. He had lived with the Watt family for much of the 7 years prior to his murder, kept as a domestic slave and tortured over much of that period, including through beatings and knife wounds. As early as October 2001, more than 7 years before he was murdered, Michael told Luton Social Services that he wanted protection after a dispute with James Watt and Watt's mother. This was one of many missed opportunities to help him find safety away from the Watts. In both these cases, involving victims being abused by people they were living with or who had access to their home, it is likely that the abuse perpetrators would have denied the local authority access to the suspected victim in the absence of a legal power of entry. The Commission believes the power of entry with appropriate safeguards, combined with the proposed duty of local authorities to make inquiries, will enable more effective interventions in response to allegations or suspicions of abuse and neglect. The Commission accepts that the interventions of public bodies in response to allegations of abuse and neglect of adults on private premises raises complex human rights issues. Under Section 6 of the Human Rights Act, a public authority must not act incompatibly with rights under the European Convention on Human Rights. This requirement extends to courts and tribunals. These Human Rights Act provisions would help ensure that a power of entry is used in an appropriate and proportionate way that ensures people's safety and security whilst not being overprotective. In practice, an authorised officer applying for a warrant under this provision and a magistrate considering whether to issue a warrant would first consider whether an individual is at risk of serious human rights abuse amounting to inhumane and degrading treatment in breach of Article 3 of the Convention. This is an absolute right, which cannot be restricted under any circumstances. If a local authority or the court knows or ought to know that a vulnerable person is suffering ill treatment, it may be under a positive obligation to take urgent steps to stop the abuse. The proposed amendment to the bill would facilitate the fulfilment of this human rights obligation. If the individual appears to be experiencing abuse that falls short of the threshold of inhumane and degrading treatment, the Human Rights Act would require a slightly different approach. Entering into a person's home is potentially a breach of Article 8 of the European Convention on Human Rights, which can only be restricted for a legitimate aim, which can include public safety and protecting health, and in a way which is proportionate. An authorised officer applying for a warrant and a justice of the peace considering whether to issue one would therefore have to consider these factors. Another relevant source of human rights standards is the United Nations Convention on the Rights of Persons with Disabilities, particularly Article 16, freedom from exploitation, violence and abuse. Under Article 16, the UK Government is required to take measures to prevent all forms of exploitation, violence and abuse of disabled people, both within and outside the home, and to investigate and to prosecute those responsible. The Commission has recommended further safeguards for power of entry. For example, local authorities need to establish if the person they are concerned about or any suspected perpetrator has specific communication needs and ensure any needs are provided for. Local authorities should also consider using independent advocates to make contact with people they are concerned about and when exercising a power to enter. This may be particularly appropriate where the person of concern has a historically bad relationship with the local authority. An independent advocate can help to ensure that a person's wishes are clearly articulated and that proper consideration is given to balancing the person's human rights to ensure the least restrictive course of action is taken. In conclusion, based on this evidence, the Commission supports this amendment.